Welcome everyone, and thanks for joining us today for our navigation webinar. Presenting today is myself, Brenton Fielder, Senior Financial Lines Underwriter based and also joining us is Nicole Carey, who is our National Product Head for New Product Development, and Andrew Clark, who is our Claims Team Lead in Sydney. Before we start the session, we'd just like to go over a few housekeeping topics. So today's webinar will be recorded and a link will be sent to you in the next couple of days. Alternatively, it will be on our website by the end of the week. During the session, we invite your comments and questions. Please select the Q&A section on your screen. And throughout the session, they'll have a couple of polling questions with Slido. Once the question pops up, you can add your answer. Having any issues with sound, please try to disconnect and reconnect, or use the call-in number provided in the audio options on your screen. If you cannot see the presentation, please make sure you're using WebEx, the WebEx app, and not a browser, or you are outside your company server. In regards to CPD and CIP points, a certificate will also be emailed to you, and you can claim the points online at that or the website. So within this presentation, we'll be covering the claims process for casualty claims being management liability, professional indemnity, and public liability. And we'll be going over the following topics. What is a notification? Is there a policy in place? Is the insuring clause satisfied? Do any exclusions apply? Is coverage sublimited? Should panel be appointed? And also management of the claim. Nicole, you've just received a call from your client to let you know of a potential claim or an issue that they may have. What's your next steps?
Thanks, Brenton. So I'm going to put my broker hat on for a little while, and I've got a little bit of qualifications. I used to be one, so that's okay. I can still pretend to be one sometimes. So I've just received a call from my client who's in a little bit of a panic because they've got this circumstance that might give rise to a claim under their policy and they're not really sure what to do. So I guess the first thing that I need to work out as a broker is what are they talking about? What are the facts of the particular incident or occurrence that they're talking about? And once we establish that, what the facts are, we need to have a look at what the appropriate policy would be that this particular claim could go under. It's sort of, sometimes we might get a call or information about a notification, and it's potentially the claim could be under one or two different policies. When you first get the original facts, it's probably best to assess all the policies that this could potentially fall under. So just some examples of things like that. For if you've got a workplace health and safety injury on site, for example, that could potentially be an ML claim under your workplace health and safety investigations portion of your policy. If the injury is to a contracted worker, that could end up, or a labour hire worker, that could end up also being a GL claim under your GL policy if their workers' comp insurer comes back and subrogates against you. So if you've got an example like that where it could potentially fall under one or two policies, we would recommend that you notify both insurers of that incident at the time it occurs. So everyone who needs to be involved from an insurance or a defence point of view can be on the ground to help you straight away. From a financial lines point of view, a design and construct project could be something. You could have a claim under a design and construct project that could either come under a GL policy, or it could come under the DNCPI. When we're first getting the information, we don't necessarily know if it's a faulty workmanship issue, that manual physical work side of things, or if it's a design issue. So it's probably best to notify both insurers upfront that an incident has happened and then move on and go from there. So once we've worked out what the appropriate policy is, it's probably a good idea to have a look at as well, is it a claims made or is it an occurrence-based policy? So if it's a claims made policy, the policy needs to be made against, the claim needs to be made against insured during that policy period. So if it is a claims made policy, it's worthwhile having that discussion upfront with your insured to say, hey, when did you first find out about it? Because if they found out about it 2 or 3 years ago, you might need to start having some more conversations with them to find out why they haven't notified it until 3 years later, when it probably should have been notified 2 or 3 years ago. The occurrence-based ones are a little bit easier because it goes back to when the loss actually occurred, and you don't necessarily have to notify within that policy period. But this is still a good idea to find out when the insured knew about it, because if they knew about it a few years ago and haven't disclosed it on future policies, that could cause some issues as well. So I think I've covered off both of those ones there. So what we've determined so far is that we've got a potential claim, and it could be under one of our policies. The next thing that we probably need to look at and make sure that we've got correct is, oh no, sorry, I'm going to a Slido question first. So how does a broker know when to notify an incident? So I think Chelsea's going to get the question up there for you to answer. How are we going there, Chelsea, with the
Sorry, it doesn't seem to be working at the moment, so we may need to just revisit this.
All right, that's okay.
Yeah, we may need to just skip this question for now, and I'll let you know.
Okay, that's all right. Basically what we were, the response was it was going to be a true or false or an A or B question. And just the thing that we wanted to point out under this Slido poll was that it's prudent to notify a fact or matter, any fact or matter that might result in a claim. If you've got any doubts whatsoever, if you're not sure, if you think, oh, maybe it could, maybe it couldn't, err on the side of caution and notify that matter. It's best to get that in earlier. It's much easier to notify a claim and for us as an insurer to come back to you and say, hey, it's okay, it's not actually a claim or a circumstance under the policy right now, but thanks for letting us know, as opposed to not notifying it when you should have notified it and potentially having some big hills that you might have to follow or get over in the future going forward. The other part of the question we were going to add in there was, what do you do as a broker if the insured doesn't want you to notify the claim? We know that a lot of insureds are a little bit scared sometimes to notify claims or circs because they're worried that it's going to affect their premium or increase their pricing, or maybe not let them get insurance anymore in the future. Our recommendation on those ones, and I'm sure you do it all anyway, is just to explain to the insured that if you're notifying something and it's not a claim under the policy, then it's not really going to affect your premium. So there's more harm in not notifying a policy than there is in actually, there's more harm in not notifying a policy than there is in actually notifying a circumstance that doesn't give rise to anything under the policy. Okay, so we've worked out that, yeah, there's something happening. We think it's going to be under our one of our policies for the insured. So what we need to actually do as a broker is actually just have a quick look at the policy to make sure that we do have that insured noted on the policies. So the first thing we'd look at is your client insured? And the easiest way to look at this is, are they named on the policy schedule as the insured? So if they are, awesome, tick your box, get your claims form filled out and send it into the insurer. If they're not named on the schedule as an insured, there's a few other little steps that you might need to go through just to see where they are. And these steps are pretty similar to what our claims team would be looking at initially anyway when they first get a notification. So the next thing, so if the insured's not named on the policy schedule, the next thing that you could look at was the definition of insured. Does that definition of insured extend to include your client? So yes, fantastic. So that could be if it's an individual who is an employee, they're brought in under the definition of insured. If you're looking at a D&O or an ML or a GL policy, sometimes the definition of insured will extend to include a subsidiary. So they don't need to be noted on the schedule, but they are actually an insured, and that definition of insured brings them in. If, however, they're not noted, brought in by that definition, then again, we've got a little bit of a hill that we might have to, a little hurdle we might have to jump over. So the next thing we could have a look at is your client added as an insured by an endorsement? So some insured policies will add specific contractors. They can be noted as an insured via an endorsement. Sometimes some ML and D&O policies will name deemed subsidiaries. So they're not technically a subsidiary, but the insurers will agree to include them and note them as a subsidiary. So they could come in under there. If you go through this process and you don't think the insured has been noted correctly on the policy, that's okay. Don't not notify a matter because of that reason. There could be some other reasons that are sitting behind it. Still get your claim form filled out, get your information prepared properly, and send it through to the insurer and let them have a look at it. So I've got the details, the facts and circumstances of my claim. I've worked out which policies I want to put that under. Yes, I think my client isn't insured under that policy. So I've got the claim form filled out, and then I'm going to send it into the insurer, who will pass it over to their claims team. So I'm going to hand over to Andrew now, and he's going to run you through the process of how our claims team have a look at notifications that they receive and move on from there.
Thanks, Nicole. Okay, so both professional indemnity and general liability policies may respond to a kind of legal liability, but there are key differences to the triggers to cover and what the policies themselves cover. Looking first at professional indemnity or PI covers, the first thing to note is that it indemnifies claims as defined made against the insured that are made during the policy period and that arise out of the conduct of the professional business. The bigger issue, though, for a claims made policy is what happens if the insured becomes aware of something that might become a claim, but which has not yet eventuated into such. So what recourse do they have there, essentially? So where it's applicable, Section 40, Sub 3 of the Insurance Contracts Act affords a policyholder the statutory right to notify facts that might give rise to a claim. And we can refer to these as notifiable circumstances. So what are notifiable circumstances? They are facts or matters that are possessed of some objective quality capable of giving rise to a loss of some kind. So when you're considering whether something is a notifiable circumstance, turn your mind to what could be the basis for a potential claim, or is there a specific event, incident, or a transaction that objectively could give rise to a loss? And is the insured actually aware of something in the first place? A fact cannot be speculative. There must be a reasonable and appreciable possibility that a claim may arise from the fact. It is not just a bare possibility. So lastly, what is a claim? Within the context of PI policies, it is typically referred to, paraphrasing, as a demand or civil proceeding for compensation or damages. Put another way, and to give context to what the words compensation or damages mean, they're generally taken to mean pecuniary redress for an actionable wrong, meaning the compensation or damages must follow a wrongful act of some kind. So by example, this differentiates a demand or proceedings for the recovery of a debt that might be owed by the insured. That is not a claim within the meaning of the policy. If you're talking about a debt, which we're sometimes notified of, the wrongful act is the failure to pay the money itself. There's no wrongful act giving rise to a loss concerning compensation or damages. General liability policies, on the other hand, I won't go into too much detail about what property damage or personal injury might be, but it's important to look at the key differences to PI policies. GL policies respond to occurrences, being events that are not expected or intended, that give rise to personal injury, property damage, or in some cases, advertising injury. So general liability policies don't require a claim in the same sense that a PI policy might, but there are still very good reasons to notify potential occurrences, even when that claim hasn't yet been made against the insured. Informing us early on means we can make inquiries early. As time passes, people can move on from the business, memories can fade, and documents can be lost. The benefit of contemporaneous statements and material is immeasurable when trying to defend a claim. Claims rise and fall on their merits, and trying to resist something without any evidence behind you is incredibly difficult. It's important to remember that we're working in partnership to protect the insured's interests, which is the name of the game here. We can't defend something if we don't have anything to back us up. Next page, please. Management liability policies are often written on a claims made basis. They provide many different covers, and I won't get into all of them here, but it is worthwhile taking note of probably the biggest parts of, or the most valuable parts of an ML policy. Employment practices liability, statutory liability, tax audits, and employee theft and third-party crime extensions. These extensions, in addition to the main covers for insured persons and company liability, are of great value to insureds. Cover for legal costs against regulatory attention is significant. Investigations and prosecutions can be highly costly and are becoming more and more common, especially in the WH&S space we see. Just briefly, covers differ for the company versus an insured person. Cover for a company could be criminal proceedings or demands or civil proceedings for compensation or damages, whereas a claim for an insured person extends out slightly to also include claims for non-monetary relief, which broadens the cover available to a director, an officer, an employee. So that's important to take note of there. I think it will be back to you, Nicole. Unmute, Nicole.
Okay, let's see how we go with this Slido question. So are all insuring clauses and policy definitions the same across the market? You should be able to see that on the right-hand side of your screen. I think we can probably close that one off, Chelsea. It's a pretty clear winner there. So, which is a fantastic response. So the correct answer is there that whilst they might be similar, there are differences. So this comes back to before we're even notified of the claim. This question comes to the point of when you're actually putting the policy in place initially. It's really important for you guys as brokers and even your insureds to understand the operation of the policy before that cover is put in place, and compare the wordings to make sure that if you're recommending one over the other, that you're potentially not recommending a policy that has a lesser cover and could cause an issue for your insured when a claims arises down the future, and potentially even for you if that claim's not covered under the policy that has the lesser cover. So that question sort of leads on to the next question, which we'd be looking at. This one is something, again, that the claims team would look at very, very carefully. And is a business or service covered? So the response to this question is generally, there's a lot of crossover between the claims and the underwriting department when something comes in under this sort of thing as to is the business or service covered? So once again, the first place we'd look at is a policy schedule. What does a policy schedule state? If we're insuring an accountant who's also providing engineering advice, which would be two separate policies, but we'll put that aside for the sake of the example. If we've got an accountant who is also an engineer and the policy schedule states that we're insuring them as an accountant, we're not going to be covering them as an engineer under the policy as well. So that's the first place we would look, is the policy schedule to say what it states, what's their actual professional services that we think we're covering as the insurer. The next place we look, you'll see this is a similar process to what we follow through when we look at the definition of insured under a policy. So is there something in the policy wording that extends what we've said in the policy schedule to extend out that professional business, to bring that in? If something's not specifically stated in there, is it somehow brought back in within the policy wording? Sorry. So if we're looking at the policy and at this moment we're still not sure if it's covered or not, if the professional business is covered, we need to go back to the proposal form and have a look at what information was actually disclosed to the underwriter. So if you've got an insured who's started undertaking services that are in addition to what they've previously disclosed to the insurer, they're not necessarily going to be covered if they haven't been disclosed previously. If they have been disclosed previously, you might have a little bit more weight to sort of have that discussion with the underwriter and say, well, hey, come on, this was disclosed to you, you haven't excluded it somewhere, so maybe it is covered or isn't it covered? And that sort of discussion would probably lead on to the next question, was does that activity form a normal part of such professional services? So if, for example, I'll go back to the example of an accountant. If we just received a proposal and we just said accountant, and in their proposal form they had disclosed that they were an accountant, they did some accounts prep work and they did some auditing work. The policy wording is not excluding any auditing activities. You would generally think it's normal for accountants to undertake auditing work. So that sort of thing would fit in under the policy. Where you'd have an issue would be if it's an accountant and there's an auditing exclusion on there. So if it forms a normal part of those services, then you're probably going to be okay, but you still need to check that and make sure. I just referred to the next point there, is the activity excluded by endorsement. Sometimes you might have a very broad definition of professional services, and then that's limited back by an endorsement, which is perhaps excluding a coverage, or it's sublimiting coverage for a particular area of a professional services that someone undertook. And then the final bit that we've got down the bottom there, and this is assuming that it's not noted in your professional schedule and it hasn't been brought into the wording, is would the insurer have changed any of their terms if they were disclosed? So again, using the accountant as an example, they do they disclose that they do 95% or 100% tax work, but they actually also do say 10% accounts preparation work. If we had have known that they did accounts prep work on when the information was submitted on the proposal form, would we have still quoted it? Probably. Would we have charged the same premium? Probably. So you probably got a little bit more of a leg to stand on there as well. So Andrew's smiling at me here because he might have a different comment to say. But sometimes that's that point where I'm talking about when the discussion will come back from the claims team. The claims team will look at it and go, well, hang on, no, we're not covering that. And the underwriter will come back to, the claims team will come back to us and say, would you have covered it or not? And we'll go from there. So I'm going to hand over to Andrew now. He looks like he's itching to talk anyway, so.
Thanks, Nicole. No, I just like the answer probably. It's conclusive. So does anything limit coverage? It's always important to pay attention to the words on the page. That's our approach. We're not concerned with intention or other subjective matters. It's a pure reading of the policy. So do any exclusions apply? This is a question of fact, and each claim is assessed on its merits. So we approach each case on the legs that it stands on. Exclusions, conditions, other limiting words always assessed on a factual basis, subject to their merits. So some extensions to cover may be subject to a sublimit. It's always important to pay attention to that and question if sufficient cover exists, particularly relevant for the ML policy. A lot of the extensions are sublimited, so it's just important to take note how much cover does your insured have. Is that cover sufficient? And likewise, similar for conditions. Next slide, please. Okay, so instructions of lawyers. So the basis of instruction can vary and depending on what is actually happening. So different reasons why we might instruct a solicitor. It could be that advice on a particular point is needed or proceedings have been filed and we need to attend to the management of the litigation. Oftentimes though, we will appoint a solicitor to make inquiries or obtain information or documents on our behalf rather than making the requests directly ourselves. We would typically do this though when the circumstances of the claim are particularly sensitive and any information the insured might produce to us needs to be protected. By getting a solicitor to do this, we can make sure that the insured is protected by some form of privilege attaching to anything they might produce. Berkeley obviously treats any information it receives as confidential, but protecting the insured means they may be able to resist any attempts by other third parties from accessing the same information even before a claim is made. So it's really important to note that we do act in the insured's interest here, and we make inquiries by reason of trying to protect their interests. But why we appoint panel lawyers? Other than the usual benefits of preferential rates and things that we aren't charged for, our panel is made up of hand-selected experts. We appoint people, not firms, and we know who has the right experience and expertise for the particular job at hand. A big part of managing and defending claims is making sure that the team you put together is made up of the right people. If the team isn't right from the outset, it can all fall apart down the line. What we do often find with non-panel appointments is that an insured's lawyer may have advised previously on the issue subject of the claim itself, and we perceive that as a conflict, as the lawyer may then be in a position of defending their own advice rather than the insured, and that's not in the insured's interests. The people we work with understand our claims philosophy of play fair, pay early, and they understand our approach to claims management. So talking about play fair, pay early, what we mean is not just rolling over and settling claims because it might be easy or convenient. It means being mindful of what we are paying and why. Every dollar that we spend is a dollar spent under the insured's policy and which attaches to their claims history. So we understand the impact of that. We always bear in mind whether a settlement is in the insured's interests or not. Paying out claims that have no reasonable basis ultimately means prices go up and insurance becomes unaffordable for people and businesses. There are knock-on effects, and that's of particular significance if you've got a client operating in the SME space. They need insurance to operate. Not being able to afford it, it puts them at risk. You also risk developing a reputation that you're an easy target as an insurer, and that's something that we absolutely try to avoid, particularly when we're dealing with claims in the personal injury space. Ultimately, we're here to safeguard the insured's interests. That is the point of the policy and the point of us getting involved early. The sooner the better. The next slide, please. So, defending liability. There are many factors that decide whether a claim can be defended. Each claim rises and falls on its own merits. Usually some key factors are whether there are reasonable prospects of mounting a successful defence. Obviously, it is not in the insured's interests to incur costs of running a trial when we have no prospects of winning. How will the insured's witnesses present in court? That's a big factor. Giving evidence is not a fun experience. It's incredibly stressful and it can take a toll. Whether a witness is likely to hold up under cross-examination and stick to the facts or their evidence or get tripped up is an important consideration for us to keep in mind. And that comes down again to the team that you put together and how well you prep and brief your witnesses. Will the witnesses even be favourable to the insured? Employees can move on, find other work. They might have moved on amicably or under less than ideal circumstances. They may not hold the insured in a positive light, and this could colour the evidence that they give. Obviously, we don't want to put somebody up there if they're going to be trashing our insured. That's not a good look. Ultimately, each claim is assessed on its merits, and running something to trial is something that has to be considered carefully, weighing the insured's interests. Settling a claim. Settlements are aimed to be achieved on the best terms possible for the insured. We make a point of attending settlement conferences and mediations in person. Managing mediations is its own skill, and when we're acting for an insured, it's important that we get a feel for the parties in the room so we have the best shot at achieving a good outcome for the insured. We never abrogate our authority or responsibility to others or give a solicitor a certain amount of money that a claim could be settled up to. In our eyes, that's not claims management. We handle the claims ourselves and how much we're agreeing to settle something for. Finally, denials of indemnity. We do have a very stringent process concerning denials of indemnity. Before coverage can be declined, the reasons for the declinature and the claim itself are reviewed by 2 senior members of the claims team, typically me and our other claims team leader. If we agree with the denial, it is then referred to the National Head of Claims for review and final approval or rejection. So before a denial goes out the door, in addition to being reviewed by the claims adjuster handling the matter, the denial is reviewed by 3 separate sets of eyes. A denial of indemnity is something we take very, very seriously. If our decision is disputed, we are more than happy to afford the insured with every opportunity for an impartial review. We will refer the matter to a panel solicitor and ask for their independent opinion on coverage. We provide them with the factual material that makes up the claim. We never tell them what we think of the claim or the policy. We just ask them for their opinion. Once that opinion is delivered, we choose to be bound by it. If the outcome of the review is that the claim should be accepted, then that's fine. We accept it regardless of what we might think of it. We don't go back and argue with the person giving us that opinion. If the opinion is that the claim is, or that indemnity is rightly declined and that position is still disputed, then we will refer the matter again to counsel following the same process as previously mentioned. Again, we choose to be bound by the outcome of counsel's independent review. And finally, if the position is still disputed following those 2 prior reviews, then we'll refer it to senior counsel for a similar independent opinion. And again, we choose to be bound by that. So the process that we follow is aimed at giving the insured every opportunity for a fair and independent review of their entitlement to coverage under the policy. And it's something that we take very, very seriously. And I think back to you, Nicole.
Thanks, Andrew. Yeah, I'd just like to stress there that it is a very rigorous process when we go through before we deny a claim. It's not something that we take very light-handedly because we're in the business of providing insurance and that's what we're there for. So our next Slido poll that we have is Berkeley Insurance Australia is an APRA approved insurer. So this should just be a true or false question. Hopefully popping up soon. Thanks, Chelsea. So the correct answer on that one is true. Berkeley is an APRA approved insurer. So when we're not an underwriting agency, that means all decisions that are made in relations to claims and whether or not we pay them, they sit here with us in Australia. Andrew, can you just shed some light on that, on what sort of effect that can have on when you're in those mediations and things like that?
Absolutely. Difference between us being an APRA approved insurer means we hold our own claims authorities. So when we're in the room at a mediation, we can make decisions there and then. We don't have to go off to our security, which doesn't exist, to get authority. We're not delegating our authorities to TPAs either. It's us in the room. We can make decisions there and then. So that just means the process is sped up. Claims can be resolved on the day.
Thank you. Okay, so I'm sort of putting my underwriter / broker hat back on again. We've submitted our claim. Andrew's approved the claim and we've paid out the settlement and everybody's happy. And now we're coming up to renewing the policy going forward and just looking at the insured's insurance program. So some claims that are made against insureds are just really random one-off events and they're unlikely to happen again. So, but after a claim has happened, there's some really sort of important steps that an insured needs to look at, and you as a broker probably need to help them to move through that process. So the first one is, if the claim's not covered under the policy, is it something that could be covered under the policy in the future? So do you need to amend their insurance program that they've got in place so that that exposure, if that exposure could happen again or is likely to happen again, do you need to amend their their insurance program to fix that up, to try and cover off that loss for them moving forward? Yes, they've had a claim, but the next sort of part of the steps hopefully will come in and help you if that is an issue there. So risk management, after the claims occurred, what has the insured done? Have they changed their risk management procedures to try and prevent the recurrence of that claim again? What procedures have they put in place? So the most important action that should be undertaken after a claim, whether it's covered or not, is for the insured to review the circumstances and procedures around that claim and determine if there are any changes that could be made to their procedures, their operating procedures and services, to either minimise the chances of that claim happening again, to minimise the costs or expenses incurred that are happening with that claim again, and then implementing those procedures in place. So the big important bit that comes in when you're coming up to your next renewal would be to detail all of that information for your insurers. Have a meeting, sit down with your insurers and say, hey, yeah, we know we had this claim, but since then we've gone back and we've done a past review of what led to that claim, what we could put in place to stop that happening again. We've had some examples where insureds have been very nonchalant and they're like, oh, well, it's just an error, it could happen again. That's not what an insurer wants to hear. An insurer wants to hear an insured is taking responsibility for their claims and doing as much as they possibly can to prevent them happening again, or to prevent such large claims happening again. So unfortunately, sometimes when people do have claims under their policies, the roll-on effect will be an increase in a premium. Ways you can manage that is perhaps sublimiting the cover for that particular area where the claims come from. That could give you some premium savings. Other ways to reduce that premium increase could be increasing your deductibles or your excesses for that particular area or across the whole policy. So they're just a few sort of final tips as what you can do as brokers at the end and letting you know what we want to know as underwriters when you come to us to renew the policy after that. So what we want to see is that the insureds putting their own risk management and procedures and things in place, and not just using this insurance piece of paper to cover them off for everything else. The insurance policy should be part of your risk management procedures and processes, but it shouldn't be the ultimate goal of your risk management procedures. So that's all we've got prepared to chat to you guys about now. Brenton, are there any questions that have come through there?
That I can see so far. But if anyone has any, please pop them in now. We've got a couple of minutes and we can try and run over them.
No, it looks all quiet on the Q&A front, so we might wrap it up. Thanks for your time, guys, for taking time out to listen to our webinar. I guess the main points we want to push across this is, don't be scared to notify. If you've got a circumstance or a claim, don't be scared to notify it to us. And as Andrew kept stressing through his presentation, we're here to work with your insureds and get the best outcome and process for them through the claim. So we're here to work with them and protect them and make sure we get the best result for everyone. So do you have anything else to add, Andrew?
That sums it up perfectly. Thank you.
All right. Thanks, everyone.
Thank you.
Thank you very much.